Lord, in
Mr. Bhushan,
yes,
let me say at the outset, we have not been entertaining any contempt petitions. In fact, all of them are pending.
Volume out.
Good. Any notice in
Out.
any of
Volume.
we have not been entertaining any of it.
pardon, Lord.
We have not been entertaining any contempt petition or applications. What we have been directing is,
Yes.
wherever there is an issue, please approach the authorities concerned, because otherwise we'll be flooded.
Actually, what has been happening, I'll just tell
We'll
you.
be flooded with matters over
We have
here.
approached.
Then please approach the High Court after that.
Pardon, Lord?
Please approach the High Court. if
But
you
it
want.
is your Lordship's order.
I know that.
Certain out down.
Just see the terms of the order.
We have seen that, Mr. Bhushan. There are so many matters of this nature which are coming before us. It will be impossible
I
for us to deal
understand.
with them.
I understand. But if your Lordship directs,
We
If your
will
Lordship-
permit you to move the.
this will actually, my Lord, this will go on unless this court cracks the whip even in one case.
No, Mr.
Once-
Bhushan, we will not be able to do it. There are matters coming from both the sides. There are issues coming from both the sides. We have not done it even in earlier matters, and I will not make an
But
exception.
Lord, this is so serious. Just
Mr. Bhushan, other matters were equally serious. We managed to control it by passing those orders. Several cases we have been able to, and in fact, there is such
but
anything.
the problem is, my Lord, this is going on repeatedly for the last.
Mr. Bhushan, we are aware of it. We are keeping it track of it. Many cases we have been able to solve that. Mr. Nataraj, you are appearing in this matter?
Please, yes, I'm here.
Mr.
Yes,
Nataraj,
I'm here.
just please tell the
Yeah.
authorities to keep a watch. There are orders
Very well.
already.
Yes.
That they must keep a track
Yes.
of what is happening. Video recording, if it is required, that has to be done. The
Yes.
nodal officers must keep a track of what is happening.
Please, we'll do that. We'll do that. We'll take
The mere fact that we are not entertaining the contempt doesn't mean that any
That's right.
the violations will take place of our orders.
Yes. Yes.
Because really speaking, this is an order saying that no offense will be committed. There are sometimes there are no offenses committed. We can't.
Lord,
Right.
the peremptory nature of this court's order was.
Mr. Bhushan, we are aware of that. Don't keep on repeating. We can't do that. We have not. It's not the first case. There are a number of cases where we have not issued.
But if it continues to go on.
Mr. Bhushan, we have a problem. We are not saying there is no problem. That's why we kept the matter pending. But then we have to also accept that all matters cannot come to the apex court.
But my Lord,
If I entertain one, I'll have to entertain all.
No.
Sorry, Mr. Bhushan.
It will stop.
No, Mr.
Once-
Bhushan.
once-
Mr. Bhushan.
Once the court
We are,
cracks the
we are
whip
trying to stop it
in
without.
one case, it will stop.
No, Mr. Bhushan, right on.
Somebody or the
Mr.
other
Bhushan,
will
that's
be
all.
held accountable.
Mr. Bhushan, that's right on. We are not inclined to entertain the present contempt petition and leave it open to the petitioner to to the applicants to take recourse, applicant petitioners to take recourse to appropriate remedies as are available to the law. At the same time, we deem it appropriate to reiterate our earlier orders which require the district authorities, including the nodal officers, to take all precautionary as well as other measures to ensure that there is compliance of law and the orders passed by this court.
Please, we'll do.
In this
Complete.
case, there was an additional problem. There was that the bail condition of this gentleman
You
was.
can ask for, in case he makes that statement, you can ask for cancellation of bail. Will you come directly to the Supreme Court for that?
The police has to actually, my Lord, cancel his
please,
bail,
no,
has to
please.
move for cancellation of his bail.
You can ask, the party can also move.
My Lord, the High Court has proceeded on a completely factually
Why?
sound premise.
In fact, let me put it, you have not filed the relevant paper. Page R, which is
No,
the
actually,
page.
my Lord, we filed it. It was yesterday under objection. My Lord, we have already filed it.
That's
Your
not
Lordship,
present.
kindly-
Let it come up on.
Before the High Court also, it was there, my Lord. Just kindly,
You don't put the page number, you don't give anything.
Lord, I'm sorry about that. Your Lordship may just kindly see
Which is the page? Which is the next R?
our reply to the show cause, my Lord, to the clarification.
Not clarification. Which
Yes.
page?
That is page 21 in this edition document. 13th June, we sent the reply, my lord. And we have got it acknowledged. We sent it by hand as well as by email.
As per the judgment also, you did not give the reply.
My lord, that's what I'm saying. It's a factually wrong premise.
But you over here don't also file it. Where is the acknowledgement over here?
My lord, your lordship may kindly see.
Where is the acknowledgement on
These are
page
the
2021?
The email and with the acknowledgement, my lord. In fact, they did not file a parawise reply to our petition,
Maybe, but in
and we annex it.
the High Court also says the reply has not been filed.
No, kindly see.
Just 1 minute, let's
annexure-
read it. Let's read this.
Exhibit N.
Just 1 minute, please.
Lord, page 332.
Just 1 minute,
Yes,
please.
yes, my lord. 22.
Number 3 is, what is this? You provide forget about 1 and 2. The third one is not complied. You say, please provide me a format of affidavit. What is this?
My lord,
Affidavit can be provided, can be written by anybody.
my lord, in these tenders, they normally have lot of
Oh, no, not
annexures
required.
and
No,
formats.
the one, even one is enough to throw you out. You say, please provide me a content of affidavit. You can draft an affidavit yourself. Others have done it also. Sorry,
Just kindly see, my lord.
no, Mr.
Lord,
Even
couple
one,
of-
you have first not filed it, the third is certainly not compliant. Sorry.
Your lordship may see page 140, my lord. They say that it has to be in a format. Just
Format,
kindly see, 159.
you could have, others have done it, no? Others could have done it, you could have given that.
They should have responded, my lord.
No, no.
They should have
Not
responded.
required, not
And,
required.
and kindly see, my lord, under the procedure, the requirement was that they will upload the rejection of technical bid. After 1 week, they will open at least minimum 1 week. They open within 7 minutes of that. The whole purpose of that was,
That will not.
my lord, kindly see, the whole purpose was that if there is any clarification required, we are able to do.
No, they issued, they very fact that they must have opened the technical bid. Therefore, they came to know that your papers were lacking. Therefore, they asked you for those details.
My lord, after that, after the technical bid rejection, they are supposed to give reasons. This is the rule.
No, that-
This is the
that-
tender
that's been
condition.
rightly
They will
dealt
give
with.
the grounds. They
No.
don't communicate the grounds. And within minutes of that, my lord, they
That
open
has been,
the,
that has been dealt with, rightly, it's an administrative order when you reject.
and June my lord, kindly see, June they had sought
The
the
contract
clarification.
has been entered into, is working now.
My lord, in fact, he is not even eligible on the face of it. The minimum requirement was 7 years. His earliest contract, which he has furnished, is
That's been dealt with,
2021.
that's been dealt with in the review.
My lord, that,
We are not
with
inclined
respect,
to-
that has
yeah.
not been dealt.
Sorry.
7 years, he is not having that clarification.
We are not inclined to interfere with the influence judgment and especially petition is discussed. Next case.
Wait, please. My lords, in the morning, were saying that perhaps the bench was not aware when it was ordered in November that the original sheets have been destroyed. My lord, please see page 577. On 6th December 2022, the statement had been made by the commission that the original OMR sheets have been destroyed. Therefore, my lord, it was known even by 2022 and 2023 when the order was passed, my lord, the bench was aware of it. My lord, I just wanted to, now if I may continue, my lord, page 954 I was on.
Yes.
Please see 954 at the commencement of hearings also. Now, he draws attention of the court, fifth line, to the contents of such affidavit and submits that in response to a right to information application made on February 24. School Service Commission by a writing dated January 18, 2024 stated that School Service Commission possesses the OMR sheet He draws attention of the court to the photocopy of the OMR sheet as made over to Anindita Bera by the School Service Commission. He submits that the School Service Commission is in possession of the OMR sheet and therefore School Service Commission be directed to produce the same. I don't know. The completely conflicting. Now kindly come to Millard, page 950, next page.
This will go against you, in fact.
Millard, no, if it is there, the best.
So completely, when they make the statement that the State Service Commission is in possession.
Millard, I am now being damned without being heard.
No,
without
you're not.
production
You're
of
being
the
heard
record.
over here.
Yeah.
You're being heard over here.
Millard, I'm grateful to my lords for hearing me. Millard, page 955. My last two lines. He submits that Honorable Supreme Court restrained publication of OMR in the public forum, submits a record to be considered by the court prior to deciding the admissibility of evidence. Affidavit filed today should not be taken on record. So-called OMR sheet annex should not be taken as side to side. Now, skipping one paragraph, learned Deputy Solicitor General submits that seized electronic devices were sent for forensic examination to Hyderabad. I'm sorry.
For 955,
Next. Learned deputies, page 956.
956.
Yes, ma'am. Third paragraph. Learned Deputy Solicitor General submits that seized electronic devices were sent for forensic science examination to Hyderabad. And the Central Forensic Science Laboratory at Hyderabad, who by writing declined to examine the same since the materials containing the electronic devices were voluminous in nature. Hyderabad at CFSL was returning such materials he submits are expected to reach. Therefore, no examination. See, then Millard, kindly come to page 1013. This is the proceedings of 5th February. When the original of 65B certificate is produced to file, etc. But I'll skip that part of it. Please go over to page 1015. Learned advocate appearing for the School Service Commission files a sealed envelope containing hard copies of candidates in the panel and waiting list showing OMR marks. 4 compact lists with regard to 4 categories of candidates showing OMR server marks of all candidates. These be kept with the records. Admissibility of these evidence will be decided at the hearing along with other issues. In view of the order of the Honorable Supreme Court, number of matters pending and the issues required to be decided as specified by Honorable Supreme Court, we propose to hear the matters on the basis of affidavit evidence. In such circumstances, it would be appropriate to permit the opposing parties one opportunity to use affidavit dealing with the documents are to be relied on by the petitioner and other parties filed today. Then, we actually file affidavit. I'm not, in view of the shortage of time, I'm not taking my lords through all the affidavits, but kindly note the pages, Miller. 2760, 2808, 2838, 2853, where we have filed affidavits, raising objections, and Miller setting out in detail why these are not authentic, cannot be relied upon.
What cannot be relied upon?
Yes. And Miller,
what cannot be relied upon?
No, the records produced and the status of allegations in the status report of CBI are not substantiated.
Please. That even the SSC is accepting. Please, we will not argue on that. Don't go on that.
I'm saying that the data, basic data on the basis of
No, they have even accepting. That's not going to all that.
Somebody should consider them.
God,
Nobody has considered. High Court has not even dealt with our objection.
You're going to the other extreme.
I am the person's allegedly tainted person. I am saying there is no material to show that I am tainted.
Probably deal with the prosecution then.
The problem is that my lords keep repeating every day that everybody should be given an opportunity. Here I am before my lord saying that there is no material which can be relied upon to say that I am tainted. And nobody
arguing that in all the cases of those 20 or 20 lakh students, application should have been number 1. Number 2, that 25,000 should have been issued show cause notice. Number 3, at least those 15 or 30,000 or 40,000, 4 or 5,000 who had whose marks were found to be manipulated. How can that be possible?
Somebody
You have
has
be
to
realistic about it.
demonstrate, either the petitioner or
They
CBI,
have
somebody.
demonstrated, please. Look, we have to believe SSC themselves say, yes, they are wrongdoing. They are not hiding that. The board also says there is wrongdoing. The ones who are appointed.
The authorities who are
The-
supposed to have
the
colluded.
CBI The CBI also says there is wrongdoing.
Well, CBI is
Somewhere
the
you'll have
person,
to-
well,
We
the
are going back,
authorities,
we are going by preponderance.
well, the authorities who are supposed to have colluded in this, they say they are okay. See, what CBI says is gospel truth.
In fact, they had to concede because they were cornered. That's all. That's next
Well,
page.
they want to extricate themselves from this. Well, there is nothing to demonstrate that we are in any manner tainted. That's somebody has to take on the onus. Nobody has produced any document. That we have written the exam, we have passed, we have got good marks, we have been selected, we have been appointed, we are functioning. Now, we are being thrown out without even anything being proved against us. Now, kindly see, page 1016. So far as the prayer of Deputy Solicitor General with regard to original electronic devices are concerned, it would be appropriate to permit the CBI to produce such originals with CFSL Calcutta. Let they were to be produced, then who require inspection of OMR sheets may send such requisition. Now, kindly come to the judgment. I have given the affidavit pages. Our written submissions elaborately deal with each one of the objections. They are at page 2868 onward. 2868 onward. None of this is considered. Kindly now come to page 210. 210.
Yes,
Let para 240 the chart.
yes.
Let this doesn't match. CBI by SSC has submitted a statistical report. CBI gives another report. Not these do not tally. This contains one number. There is another number. Kindly see page. Compare this with page 248. Para 305. The numbers given here or do not tally with, there is no manipulation of 950 numbers. Here it says 993. There is nothing matching in regard to any one of this. Now, please see page 273. Para 273. SSC, para 273 at page 229 or 227. I have 227.
Para 273 at page number?
I think either 227 or 229. 227, yes. SSC had at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities of recommendations, but had limited it itself. Therefore, SSC has not checked. Now, kindly come to page 288, or para 288. Now, kindly start with para 286. Order of remand dated November 9, 2023, passed by Supreme Court in relation to present matter, has required us to pronounce on the admissibility of data contained in the 3 hard disks. Issue of admissibility on the data contained in the 3 hard disks have been raised by the beneficiary of the fraud. You have already come to a conclusion, I am the beneficiary of the fraud, without even deciding on the admissibility. Kindly look at this, therefore I am condemned. And then thereafter, I put on a peg. And none of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity, and legality of data contained in the data. If they don't, I have disputed, I have filed affidavits, I have produced material.
How can you dispute that? That's a just checking of mark sheet, all that you could have.
I am saying,
How can
this
you
is
dispute
not
that?
what you are showing as the OMR sheet.
Your OMR sheet is something different from the marks you have obtained.
Therefore,
You are not privy to that.
there has to be some method of proving that I have not secured the marks which I claim I have got.
They
and
have
based on
examined that. They have examined that.
Yeah.
That
Let-
they have examined.
attending by SSC.
You are in one of those categories where the marks were different from the OMR sheet?
Yeah, no, I'm in the second set of category where Mr. Jaideep Gupta has in the affidavit, not the one who jumped, not the one who has been brought, taken through the back door, but whose marks don't match with the OMR. Yeah, that's right. 288.
You are the one who marks don't match, no? The one-
How am I?
No, you-
Can I be asked to prove?
One minute, please.
Can the onus be put on me?
No, there's no onus on you. Because you were never aware of the marks also, so you're never aware of them.
Therefore, how do I disprove? How do I prove that?
We were aware, marks were published. I am also in the same category. I'll
Okay.
just take 5 minutes after him, but marks were published.
Marks were published, but you're not the marker.
But I'll respond after he finishes.
You're not the checker.
I'll just respond after.
Yeah.
You're not the one who checked it.
I'm also in the same category, but I'm going to.
Good.
Completely different suggestion. I'll deal with it after.
Para 288, SSC had accepted such data, acted upon it, found manipulation, illegalities of the OMR sheet, proceeded on the basis of findings, it had utilized such data. Therefore, they say, we will act on it. In my respectful submission, we dispute it, we deal with it in our affidavit. That's the only opportunity given to us, nothing else. We have put in our written submission, none of those are considered.
Okay.
And we were, kindly now come to page, para 294.
Yes.
In our view, the fact that the 3 hard disks contain data related to 4 categories of selection process conducted by SSC had stood proved by whom? By SSC and state making admissions with regard to in the application filed in the writ petition and by the court. And again,
You've understood your argument that you don't believe that the SSC's acceptance that there is wrongdoing is correct. Though they themselves says we are the checkers, but we made mistakes. We have done some bungling. You say don't accept them. Because according to you, you never gave the exam, but you did not.
No. We gave the exam, we have been selected. We have got the mark.
Your only thing is because you gave the exam, so therefore don't believe the SSC who themselves.
No, we gave the exam.
No, not only this, there have been 2 committees nominated. The 2 committees also.
No, they didn't go into the hours. They went into some other set of
Committees
That-
for Group C and Group D,
D.
not for assistant teachers. So there are 4 groups. Group
Yeah,
C.
he's in group C. He's not in group C.
I'm in the group
I'm assistant.
level 9 and 10 and group C. But level 9 and 10 I am appearing.
So
Level 9.
the committee who went is wrong. The SSC who accepts is wrong. CBI who's done the investigation is wrong. The court which has gone into that question of with reference to 65B certificate is wrong.
Let CBI
And-
therefore finds,
I don't get your opportunity.
kindly see the
That's
anomalous
all-
situation.
That's all, please.
Let's see the anomalous situation. CBI finds
That's all.
government, SSC and
Yeah,
board
but-
have colluded.
Now, that's all. Next somebody else.
Just let me submit what my learned friend.
Anything
Wait.
else? I don't
Let
want to
para-
ask you.
Para 307, in my respectful submission,
Excuse me.
on the fact that the proof, according to them, all the relevant parties have admitted. Therefore, I am not even a relevant party. I am the affected party. My submission is not considered, and all the relevant parties have admitted.
You are the affected party, not the relevant party.
Very well.
Sir,
Just give me 5 minutes.
I will also take 5 minutes.
Yeah.
Not take more than 5 minutes.
Let me try to persuade him on the one point. The whole issue is the court finds, the board doesn't find, the government doesn't find. The court finds for the first time that my marks, there is a mismatch. What is the starting point of that mismatch? The OMR sheets recovered from this Mr. Pankaj. That is the whole basis of saying that there is a mismatch. Otherwise, there is no other basis of saying that there is a mismatch. Now, please have page 305. I just want to read that CBI affidavit. that can this OMR sheet be at all relied upon? Because everybody today says there is a mismatch, but the basis of everybody saying is because what the board says, board doesn't have OMR sheets, board has destroyed those sheets, board probably has some score or doesn't have some score is not very clear, assuming that the board has a total score and an OMR sheet is recovered and that score is not tallying with the OMR sheet record, and therefore it is said that there is a mismatch. Now please see just 4 paras of that affidavit. Now, according to me, this affidavit at this stage, which is merely part of investigation, cannot be relied upon. Your lordships just observed when my learned friend was arguing that every authority says that there is a mismatch. But the point is, every authority is saying on the basis of the same recovery from that gentleman. And that gentleman in his 65B certificate says, to the best of my knowledge, this is okay. 25,000 people cannot be ousted on that basis, my lord. The facts are, the assistant teacher process starts in 2016. In January 2019, we are appointed, we are working. Up to August 22, there is no challenge. The first writ petition is filed in August 22 after almost 3 years. In that writ petition, we are not made parties. At some stage of proceeding of that writ petition, the court says, let there be a CBI investigation. We are still not parties. Ultimately, my lord, Ultimately, my lord, one fine day, the court passes an order on 2nd April 2023. The court passes the first order on 2nd April 2023, directing the board, 2nd February 2023, directing the board to exercise power under Rule 17. Rule 17 is a rule where if the board makes a recommendation, then that recommendation the board is entitled to withdraw. Recommendation was made in 5 years before this order was passed. The court tells the board, the commission, when it is of the opinion recommendations were made mistakenly or erroneously, it is obliged to exercise the power under Rule 17. The court says, you please look into it and exercise power. The board then comes and files an affidavit, yes, we will exercise the power. The court in the second order says, you don't need to hear them. The board says, yes, I don't need to hear them. When we get to know this is happening, we file an application to be impleaded before the single bench. The single bench rejects our application for impleadment. We go to the division bench. The division bench says there are too many of you. Some of you can be impleaded in representative capacity, but so far as 17 direction is concerned, we are not staying it. 1st March 2023 is the order of the division bench. On 1st March 23, the board withdraws the recommendation under 17. And on 1st March 23, over 5 years after we are appointed, we are thrown out. So, my lord, this is, it is in my list of dates, my lord. I will give the page numbers to your lordships in a short submission of 2 pages. So, this is what has happened. We come to this court by way of a writ petition, by way of appeal against those orders. This court stays the operation of our termination, then remands the matter back, my lord. And that order of remand has been read, my lord. But I want to read 2 parts of that remand order, my lord, in my paper book. That is at page 629. I am in this Gopinath Bhanja, my lord, SLP number 9637. Compilation 734. Compilation page 734. Please have para 734. Please have para 8 of this order. Volume 3. The remand order is not complied with. So what is confronting the court when the remand order is made is a person who is appointed in January 2019 is thrown out by the board just in a day. And what your lordship says is, para 8, I want to read, my lord, of this order. Para 8. Please have this with me. 2 things the court had to do. Neither of the 2 have been done. I will read it. Para 8. In our opinion, piecemeal proceedings are not warranted relating to disputes of this dimension and termination of service.
You have read it.
All right, just one line. It was necessary for the High Court to examine the admissibility of the OMR sheet recovered by the CBI.
They have done that. They have done that.
No, there is not a single line. My learned friends will show to your lordships. I can't show a negative.
1 minute, please. They have done that. They have relied upon the statement of the
CBI affidavit.
CBI affidavit, which relies upon the statement of the data without.
Going to address that. Full-scale reliance. My will show your lordships where the High Court examines this aspect.
Yeah, please, one thing. The OMR sheets have various details mentioned on.
I'm just going to read
One
that.
minute, please. OMR sheets have various details which is CBI. Do you think those details are not matching? They will match those, they would have matched it. They would have matched it with SSC will be aware of the OMR sheets which were circulated at that time given to the student. We were worried on that score.
May I
whether
respond?
OMR sheets have been changed or not.
May I respond?
And why
Nobody has.
the person from whom they have collected the OMR, he himself getting into a problem. What
SSC.
else?
Yeah, he's an accused now.
He-
SSC.
So will he get
SSC in its proceedings have recorded all our record is destroyed.
You want to believe us that factual?
No, my lord, just allow me to just proceed. Now, I'm conscious of what has fallen from your lordships. That is weighing in your lordship's mind, my lord. I have been seeing it, and unless I can meet that I'm going to get nowhere. So, my lord, I'm just going to come to that straight away. But just one more line. So, first thing which remand order said, first please examine whether it is at all admissible. Because, my lord, right from the Taj trapezium and earlier judgments your lordships have said, these status reports are investigation. They are not gospel truth. Unless they are unless they are tested in a trial, you cannot base findings on them. That's what your lordships have said. So this is only an investigation report. Now, second, which the court said, para 10, in the course of hearing.
I had the impression that those who had tainted their appeals were already dismissed, or appeals were already dismissed.
Which ones, my lord?
Some of the cases.
No, we have challenged, 1 minute. We have challenged 65B certificate in the High Court saying you cannot rely on it. Those writs are segregated and they are still pending in the High Court. My writ, which I had challenged 65B, High Court says I segregate it. It is still pending. Where your lordship said, before you do anything, first please decide that.
Okay.
Now this is one. Second, in the course, all right, 1 minute. In the course of hearing before us, Mr. Patwalia raised the point that division bench has come to a finding that there was no necessity of hearing while applying Rule 17, having regard to the quality of the evidence that was there before the division bench. While taking that view, we are of the opinion that the question needs to be examined afresh. Let the question also be addressed by the division bench of the High Court afresh, ignoring its earlier finding. Now the court says 17 I am not going into. 65B I am not going into. Two questions which the division bench remanded, which, your lordships remanded, court says I am not going into. Now, my lord, just have that CBI status report of that 65B certificate. Because according to me, just kindly have, I'm just going to take 5 more minutes. Please have page para 305 of the High Court judgment with me. Your lordship has seen it earlier. What I'm trying to point out is, NISA, just have it with me, my lord. Well, this record cannot be relied for anything. It is a 1, 2, 3, 4, 5 party record conveniently found in somebody's residence. And that man is not even working with NISA. And there is no way he could have had this record. And after getting the record, filing it in the High Court, our termination takes place. Now he is made an accused. And tomorrow, if he says that, if he resigns from his statement and says, this is not genuine, I have made it myself, or there is manipulation, the damage to us is done already because the trial has yet to start. So therefore, just see, my lord, how just bear with me for these 3-4 paras, because it's a whole make or break so far as we are concerned, my lord. These 3-4 paras. Just kindly see. During investigation, now I'm reading the extract of the affidavit. Affidavit is on the record. In the affidavit, 5 places the CBI says, investigation is on, during investigation, this is part of investigation. So many places it is said. Now, during investigation, it was revealed West Bengal Central School Service Commission had awarded work order to NISA for scanning and evaluation of the record. This is para 3. Para 4. Investigation has referred that Puneet Kumar was the director and Niladri Das was the vice president. It has been established during investigation that Niladri Das used to do it, my lord. We can leave that. Come to para 5. Investigation has established that scanning of OMR sheets was undertaken by NISA at the West Bengal Selection Board office under direct supervision of Niladri Das in the presence of officials. It has further been established NISA had further given the work for scanning to Messrs. Data Scantech, who remained present. After completion of scanning, the processed data in the form of scanned images, scanned data were handed over by Data Scantech to NISA, who took the same to their office located in Noida, leaving the hard copies of OMR sheets in the office of the board. Board handed over their answer keys in respect of all subjects for evaluation of OMR responses. I pause here. So far, nothing has happened. That hard OMR sheet is scanned by this Data Scantech. It is given to NISA. The key is also given to NISA. Now, my lord, para 6. While scanning the sheets by Data Scantech on behalf of NISA, 2 DAT files were recorded. My lord, 7 and 8 also your lordship may leave, my lord. Then 9. During investigation, para 9 at page 239. During investigation, the server database of the commission was seized by the CBI. All data pertaining to selection of so-and-so. That during the investigation of the case, 3 hard disks were recovered on 15-16 September 2022 from the residence of Pankaj Bansal. Now, the selection process is in 16-17. You are recovering in 2022. In the meantime, what has happened? Data Scantech has bifurcated. 2 partners have separated. This Pankaj went with the second partner. He was no longer with NISA. Then the second partner's company also went defunct. Then this Pankaj joined a third company. And now he is giving a 65B certificate as an employee of a third company for ND Infotech or whatever, from something which is recovered from his residence. And this is the gospel truth on which everybody, the board is coming and saying, yes, there is a mismatch. Lord, it is too specious.
Okay,
it is too far-fetched.
So,
Lord,
Let me just complete.
Since 10:30, I am waiting, Lord. I will
Just
take 5
you
or
are
7.
the same
1 minute.
category as Mr. Patwalia's guy?
My lord, may I just say this? I have a suggestion.
I would submit, Lord, your lordship may appoint some good agency to
My
go
lord,
into.
I'm not going to re-argue or say anything about the facts. Facts are before your lordships. You've heard all the facts. The point I want to make.
I'm grateful.
The point I want to make is very simple, my lord. Without a doubt, your lordship has seen it. I'm not going into the evidentiary value, this value, that value. I'm not going into anything. Admittedly, there is some material. Admittedly, that material points to certain amount of manipulations. I'm just going on it as the worst, my lords, is what can be taken. The 2 questions which would then arise to your lordships is, what is the consequence? Now, my whole point on this is, please just see this one submission of the SCC. I'm going on them. As your lordship kept putting it to others who are arguing it, what do you have to say when the SCC itself has said so? Please see the submission. Just see that alone. Volume 6. Kindly, my lords, turn to page 16. It starts at page 15. Kindly turn to page 16, volume 6.
Yes.
Paragraph 6. It is stated that on a careful scrutiny, my lord, let me say straight away, I'm for these assistant teachers of 9 and 10.
You are
That's all.
you also fall in the tainted list?
That's why I want to read what is the tainted list to your lordships. That's why I'm trying to say.
What is this document?
My lord, this is the SCC submission
Before
on
the High Court.
the commissions. My lords, kindly see paragraph 6. It is stated that on a careful scrutiny, Commission prima facie noticed that there are candidates who can be said to have appeared to have jumped their ranks. That is to say, people having lower rank have been preferred over persons having higher rank. It was also prima facie seen that some candidates had been recommended an appointment without being in the panel or appointed without recommendation. Number of such candidates are as follows. Assistant teachers, rank jumped out of panel but appointed 185. My lords, I'm not there in that category at all. Then, my lords, I'm not on. Paragraph 7 goes on what? CBI, because your lordship said there was a concurrence between SCC and CBI. This is what SCC says. CBI says, even in the investigation, it has been found that some appointments, even in the investigation by CBI, it has been allegedly found that some appointments were alleged to be manipulated by allegedly manipulating OMR scores, which are part of that. And that is where this 808 comes in. Not 952, as it was pointed out, it is 808 on who were appointed. So the point I'm trying to make, my lords, is whatever it is, dissimilars should not be treated similarly. What has happened is, on the strength of this,
The High Court has thrown out everyone, 13,000 people. Now, my own submission to your lordship, subject to what you feel, my lords, is that SSC has found that these category of people who are not at all in the panel but still appointed or jumped rank, my lord, I can understand. But regarding others who are at that evidentiary stage, surely, my lords, we will have to be subject to whatever is decided finally, whatever this evidence brings out, whatever it finally brings out in whatever the inquiries are pursuant to this. But they cannot be treated 6 and 7. 7 is based on what CBI has said, not what SEC is saying. 6 is what SEC has found after going through the CBI reports. Now, 6 I can understand is one category, but you cannot mulch 7 in that category and say even 7 requires no inquiry whatsoever. That is all I want to submit to my lords is, number one, let the baby not be thrown out with the bathwater. Because of this, let everything not be set aside. 2, amongst those who are found to have in some way possibly been favored here or there, please deal with them. But my lords, it can't be dealt with that I'm peremptorily thrown out as item 6 would be peremptorily thrown out. This is a subject matter of some kind of inquiry. All I'm seeking is that regarding these people, let there be some kind of inquiry. We don't have a huge amount here. It's only those people, and I'm talking about the paragraph 7. That's all I'm seeking, my lords. And please do not treat dissimilars similarly is all that I'm seeking of your lordships finally here, because we have so many different categories here. We have those, my lords, who are in the 13,000, those who are in the else. That's it, my lords. And therefore, I'm only submitting, and my suggestion is only this to your lordships. Please, my lords, mold the relief accordingly based on who is in which category. But surely people whom SCC has not found have to have an opportunity, at least, if nothing else. I'm not saying for everything. I'm not pleading natural justice. I'm not pleading. But surely it can await some judging of that evidentiary content. That is all I'm saying, my lords, nothing else.
My lord, I will submit that, my lord. Kindly see section 45A of the Evidence Act. This certificate is not there. Section 45A of the Evidence Act speaks about when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer, resource or any other electronic or digital form. The opinion of the examiner of electronic evidence referred to section 79A of the Information Technology Act is a relevant fact. Now, these section 79A and section 45A, 79A of the Information Technology Act and section 45A of the Evidence Act were amended on the same day. And section 79A of the Evidence Act says the central government may, for the purpose of providing expert opinion and on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency in the central government or a state government as an examiner of electronic evidence. Now, this has been done there by the central government. Different laboratory has been established. Now, there is no certificate first for the formation of opinion or the taking into it the relevant fact. Section 45A of the Evidence Act, it has not been complied with. My second submission would be, my lord, if your lordship see the certificate.
What they say is this is a relevant fact. It doesn't give the mode of proof rate. It's a relevant fact. What is the difference between a relevant fact? Relevant fact means it's a relevant for the purpose of adjudication. Evidence Act also doesn't apply to writ petitions.
That's correct, but
Let's not go around in a tangent.
But earlier the judgment, earlier the order which has been delivered by this court, there the Evidence Act, has been,
The Evidence Act doesn't apply.
kindly just,
There are provisions of Evidence Act which can be taken into account, but it's not firstly applicable.
65B4.
Here the CFSL report has been obtained. It's a all that it says is a relevant fact. That's it.
It has not obtained. It has not been obtained.
1 minute, CFSL report has been obtained.
No,
it's
it
not
has
been
not
obtained.
obtained. It has not obtained.
There's no FSL.
CFSL report has not been obtained.
I think forensic examination of has been done. The mega data has been there. Is there, you're wrong on that.
It has not been obtained, kindly.
It has been obtained. It was sent to the forensic examination in Calcutta. That
It
report
was
has-
returned.
It has not
returned
been
that there are
recorded,
too many
declined. They have declined that they would not do it.
Okay.
It's not,
Hyderabad declined, not Kolkata.
Pardon, my lord?
CFSL Hyderabad declined.
Yes,
Thereafter, it seems to have gone to Kolkata CFSL.
my lord, thereafter, not in any other laboratory it has
The
been seen.
finding that the hard drives have not been contaminated.
Thereafter,
That was read
it has
out
not
to
been,
us.
it has been not sent to any other laboratory.
Okay, fine.
Why not? Next-
Please, there's a difference between a relevant fact and admissible.
That's right. My lord, kindly say the second point.
Experts are never the only way to prove.
My lord, kindly see 65 2B4. 2B4 speaks about who will be allowed to give this certificate. Not everyone. My lord, kindly see this. I am coming to very relevant portion. I am not reading any 65 4B.
The one who downloads gives the certificate.
My lord,
The one who downloads gives the certificate.
no. My lord,
Yes, that's the law.
it has not purporting to, kindly, my lord, just excuse me, my lord.
We
Kindly.
have read
My lord,
65 so many times.
I understand, my lord. Kindly excuse me, my lord. Kindly excuse me. The convention in the subsection to relate as purporting to be signed by a person occupying a responsible official position.
Correct.
In relation to the cost.
From whose possession the CDs were recovered? The hard disks were recovered? From whose possession were hard disks recovered?
Data entry operator, according, but kindly read this CBI report, whether Pankaj Bansal's name is mentioned there.
Okay, fine.
Not the two other persons, but who are the persons in charge of the operation? They were there. Certificate has not been obtained from them. Certificate has been obtained from a person who has left the company and went to someone. This is there from the report itself, Miller.
Not even, in fact, 65B certificate is not required because it's the original document here, the original hard drive which has been recovered.
No, it's not an original document.
It's the original. That's what they are saying. It's the original.
This is not an original document, Miller. It's an image. OMR sheet has.
1 minute, please. It's not required. Suppose email comes to you. Email comes to your computer and you produce your laptop or your hard drive in the court.
That's an-
65B certificate is not required.
That's an
That's good. That's law. The next case, please. Next argument.
My lords, very briefly, on the point of originality, my lords.
Okay, one by one.
My lords, just a very brief point on the point of originality. My lords, the OMRs are essentially a sheet with dots on it.
Not
Now,
what is
there is
OMR.
generational loss.
There in the
Round markings, dots are given by.
OMRs are in the
Precisely, my lords. Now, my lords, then what happens?
1,000 pages that were given to us yesterday. OMRs are there.
This is at page 2826 of
One
volume
one two eight.
5B.
One,
Volume 5B, page 2826.
Volume,
5B, 2826.
we don't have volume
2A.
5B by the way.
Yes, my lord, it has been given.
It's a very
There's
short.
no volume 5B in the compilation which was given.
It's all been written.
2826 of compilation miscellaneous volume 5B.
must be paying, now they must have changed the number.
2826.
But which page is
2806
it?
also.
2806 miscellaneous volume 5B.
Just scroll it, just scroll it,
What is this?
scroll it.
My lords, so while they find that, the OMR, as my lords may imagine, we've all done multiple choice tests. That is the version of the email.
How the.
Now, what is the hash value that they have compared? It is not the hash value of every individual OMR. What they are
They
saying,
cannot.
that they, okay,
It will be impossible. If they would have done that, because probably the scanned documents must be contained in one file itself. And the hash values would have come when they checked it up. What they have done is they compared hash values of two hard drives. We know when the CBI council tells us whether the hash values included the date on which they were scanned, etc. or not.
from the metadata, as my lords had requested them. But my lords, when they extracted the data from the OMR into a .dat file, there is, and I researched this extensively, across the board, there is admissions that there are generational losses. So for example, just to put it quite simply, when not today as much, but in 2019 or 2018, we used to convert PDFs into Word files. There were errors. Now, my lords, what they've done is that they have got these response strings that they themselves created. And then you have these hash values with not one generational loss, but two, because there's the .dat file, that then becomes the .dbf file, a third file. And then you compare the hash values, my lord. And so the thing is that
You are supporting complete, you are in other words supporting the complete obliteration of the result.
no, my lords, what I'm saying is this. What I'm saying, my lords, is that of course all may not be well in the state of Denmark. Of course.
You belong
That's
to
just a
which
paradox.
class? Class C and D, A or B?
I'm in 9th and 10th.
9th and 10th, C and D.
No, not C and D. C is clerical.
Non-teaching.
Not teaching.
I'm an assistant teacher in C and D.
Okay, 9th and 10th is the.
I'm 80 assistant teacher.
Tainted, not tainted.
Tainted, not tainted.
Tainted or not tainted?
My lords, I believe I am not
Not,
tainted.
not your belief. As per the order, do you fall in the tainted category?
My lords, as per the order, there are three types of tainted. And all three types of tainted are based on entirely different evidence.
Are you there?
So I am there only
One of those.
third category. So when we look at the
The
first,
third category, you got to jump in marks.
where the OMR is being challenged. So my lords, what we are saying, my lords, if I may just point to the differential in the value of the evidence between the people who are alleged to have jumped ranks.
We can break up any argument, even on pure facts or truth. Please don't do that.
But my lords,
Don't do that.
but my lords raised a question earlier, if I may.
There are certain things which are quite apparent. Let's not argue. it.
But my lords, the things that are apparent, the ex facie
Look,
wrongdoing with the
The
rank jumping.
sheets are there, the sheets are all there, the names are written, everything is there.
Or the
My
top of
lords,
the document.
all I am saying, let it face
Let's assume something.
process.
I'm appearing.
Let it go through some process. Either the criminal process, this Pankaj Bansal is going to fall under cross-examination. Or my lords, let it go through the 2018
That's not the
rules.
way writ petitions are decided.
Lord, I beg to appear for the
The
non-tainted category. I mean, the
One
non-tainted.
minute. First, let's deal with the tainted category and then.
I
we
just
go
want
to
to make a
Very
very
well.
short submission.
Then your lordship can deal with that partly tainted or tainted, then
Not as per your belief, as per the judgment if you're tainted
untainted.
or not.
Lords, maybe get back when the CBI comes back with the metadata. Maybe get back to my lords on this.
It's for us to be.
I'm grateful. I'm grateful.
We are in the untainted category where there is no taint.
That's why we deal with the tainted first and then the others.
We are all not untainted here.
Yes.
Okay, tainted on this side, not tainted on.
I am untainted, I am untainted.
Okay, let's finish with the tainted first, then we go to. Let's be tainted. Okay, let's be tainted.
There's a whole lot of confusion. What is tainted, what is not tainted. What is not there.
No.
I'm representing you come separate categories of people. One is group D, one is class 9.
You're tainted,
I don't know what is tainted.
Tainted means any report you have your names. Are different allegations. In group D, they say that I'm not in the panel. And there's no recommendation given by the commission where the board who's appointed me says commission in fact gave you the recommendation. Second category is rank jumping. Third, they say there was some tampering with your OMR, but commission says even if that one mark is taken care of, even then 31 candidates make it to the panel. I'm part of that 31 candidates. So there are three separate categories. My submission to your lordship today is as follows. What has the High Court done? The High Court has said, yes, there seems to be large-scale irregularities because of what has been said about the OMR sheets. Insofar as rank jumping, out of panel, there has been no discussion, nothing. Your lordship started off this hearing wondering if there's a possibility of segregation, and I'd like to address on that. Your lordship will see the commission's written submission has at page 17, your lordships, that is in volume number 6, page 17 of the commission's written submission, there is a table.
But you are allegedly in the tainted category. How will this help you?
I'll tell you lordships why. As far as there are two of the three categories, which are so-called rank jumping and so-called, I did not get a recommendation from the commission. According to me, I got the recommendation from commission and there has been no rank jumping. Now, these two issues are purely factual and they can be segregated from OMR. As far as my omnibus submission is, if your lordship will consider that even the CBI, the commission, whichever figure your lordship.
There's no difficulty in that.
Yes.
As far as rank jump is concerned, it's simple. Your OMR sheet is available. They have given that soft copy. You can identify your OMR sheet. You know the marks which are there. the corrected scores, you know the suggested, or the corrected, correct answers. And you also know the marks which you have been given for being selected.
Yes.
Where is the big
So
deal?
this, no, the
Why are we
big deal,
going
the
around
big deal comes,
circles?
no, your lordship, the big deal is,
I'm
I'll tell you
saying
lordships.
that, look, this is all,
No, no.
difficult to decide.
Not at all, not at all. May I just make a submission? The marks are the
It's not
same.
difficult.
In my category, my marks have not changed. The marks are same.
But you have been given more marks.
No. I have not been given. 2 of my 3 cases of no allegation of more
What has
marks.
happened?
Well, they have been given
Appointment.
appointment. Somebody above them has not been given.
It's the allegation. Is the allegation. Now may I
Jumped the
submit?
rank because of marks,
So this-
not because of the marks.
Not because of rank jumping, mismatch, and no recommendation.
So my first submission before your lordship is, your lordship will see
How do you
7.
get out then? Your marks are known,
No,
your
but
marks are
lordship-
correct.
no, the CB.
1 minute, please.
May I-
And the ones who are above you have not been given appointment, and you have been
But,
given appointment.
Lordship, that is an assumption.
I should
May I make a
say,
submission?
I'm absolutely,
No, I'm not saying, if your lordship will just kindly hear me out, I'm not saying your lordship should confirm my appointment. All I'm saying is, these are matters which ought to be relegated to the High Court, because the High Court has not even gone into this. If very well they check my papers and they find, yes, I have indeed jumped
you
rank,
had to argue, you could have argued.
we
Please,
did.
please wait.
Lord,
Tell me,
may I-
how
Lordship,
many
our
marks did you
submissions
get?
are recorded.
As per the OMR sheet, how many marks did you get?
Your lordship, I have different categories, so lordship, so many of them have made.
You would have simply filed an affidavit saying, as per the OMR sheet, my marks are so.
But it was not considered.
1 minute, please. You should have simply filed an affidavit saying, my marks as per the OMR sheet as X, Y, Z. The minimum marks required for appointment were less than this. So therefore, my appointment was right. That's it.
Yes, precisely. Now, can I do this before the High Court? Because it has
So
never
please
been.
go ahead. Please, you should have done it before us. You
Lordship,
prevented
but
from-
that was not, I'm sorry, your lordship, that is not the scope of these proceedings.
No,
Has to be a
please.
fact-finding
Please.
authority.
No.
May I make a submission? Before the High Court,
Yeah,
these
you have to-
submissions were
Let's
raised.
not go around for remand on this.
No. Okay, if your lordship will just see page 17 of the commission's written submissions, table 2, where they themselves say how many are the OMR tainted candidates allegedly according to the commission. Now, CBI may have a slightly exaggerated higher figure, right, wrong, I'm not going into it. My first submission before your lordship is, if your lordship will kindly consider segregating those who are tainted by OMR sheet allegations as opposed to the other allegations. If all of them can thereafter get heard separately, even before your lordships, we will be in a position to.
We are asking you to please tell us if you have raised that point. We are not going to go into,
Your lordship, in which case, as far as my,
you know the law, Order 41, Rule 27. You can raise additional evidence.
yes, your lordship, in which case, your lordship, in one of my SLPs, which is Sanjukta Shashmal, before your lordships today, item 1.55, I am part of 31 candidates. In this, your lordship will kindly see the allegation against me was that according to the sheets, I had got 1 mark extra, more than what I should have gotten. It is even the commission's own submission before the High Court that us 31 of the various people whose marks were exaggerated were actually within the panel. I'll show your lordships that so far as the 31 candidates in Sanjukta, in fact, my writ petition is still pending in the High Court. The
Then go
reason
before the High Court.
I have filed a leave because all my appointments have been set aside. My matter has been rendered infructuous by the order. That is precisely my problem. If my matter is pending before the High Court, but because in this other batch of OMR cases, the entire selection has been struck
What
down.
is your case?
My case is as follows. My case is, I represent 31 candidates. We got interim protection. It was stated that the marks in my OMR sheet was a mark more than what I should have been given. Eventually, the commission before the High Court
This
has
is a difference in marks then. Your
difference
case
in
is a
marks.
difference in marks.
Yes, a difference in marks. And even after reducing the so-called 1 mark or whatever I got extra, the commission has taken the stand that 31 of us, and the commission is here and your lordship can hear them, are still part of the panel. We fall within the eligibility criteria. So, which is why we stand on a complete,
Criteria or within the cutoff zone?
within the panel. I'm completely,
You will not be hit by, in your case, what
Yes.
is being hit you,
yes,
if you are being hit by is the complete destruction of the selection process.
yes,
The
absolutely,
complete novation of.
absolutely.
So that's,
So in that sense, in Sanjukta Samhay,
no, you are not on this side, you should be on that.
no, that is one of my 3 cases.
No, you are not on both the sides.
Your Lordship, so this is
Lord,
that,
may
Group D.
insofar as Group D is concerned, the allegation.
Okay, anybody else?
my lord, may I be permitted to, my lord?
Yes.
I'm on a mismatch category, my lord.
But I'm for Group D. I'm in the allegedly tainted people, my lord, although I say I'm not tainted. What I say is this, my lord. Group D, I represent about 300 candidates in Group D, my lord. Now, Group D, admittedly, there is no allegation of rank jumping or any of these things, except for the fact the allegation is that the OMR sheets are forged. Now, my lord,
Forged in what way?
my lord, in the way that there's a mismatch between the
Blank
marks-
or forged?
Yeah.
My lord,
Blank or forged?
let me amend my statement, my lord. It's a case where, admittedly, the original OMR sheets, once they were scanned and uploaded, the marks were calculated by the software on that basis and appointments were given, including to people such as myself. Those OMR sheets were then destroyed as per the rules within 1 year. Neither do those OMR sheets remain, nor does any copy of those remain. Nor, and this is very crucial, my lord, nor was any hash value generated at the time when they were uploaded. The only way to check and compare two sets of data to see whether the hash values compare, and therefore to see if anything has been changed or not, is to generate the hash value in the first place when they were uploaded. That has admittedly not been done. Therefore, if you generate a hash value of the hard drives which you found with Mr. Pankaj Bansal, what will you compare it with? There was no hash value generated in the first place. Therefore, there is no definitive way to tell.
You are then supporting complete annulment.
Yes. Yeah. No. Against. I'm serving, my lord. My lord, I'm serving.
Against completely.
I'm serving. I was terminated, and then under orders of this court, I'm under a stay. I have the job right now.
Okay.
I'm not reporting termination.
Just to
So therefore, what I'm saying, my lord, is
They're not like.
just
May
a
I-
couple of more points, my lord. I'm so sorry. Just a couple of more points, my lord. Therefore, my lord, I want to give an overall conspectus as to what it is my submission. That is the question that your lordships are deciding at this sort of interim stage, my lord, when the trial is.
Look, in your case, the OMR sheet is available.
No, my lord, it's not.
1 minute, your OMR sheet will be available. The names are also mentioned, the
My lord, it is
signature
not.
of the candidate are also there.
With great.
So then if it's not there, then you never participated in the exam.
No, my lord, that is nobody's allegation, my lord.
Obviously.
At the time when I participated.
Okay, we'll know, we'll check up.
And just a couple of more things, my lord. Just on the overall conspectus.
That makes it much worse. If
No,
that
Lord,
is correct,
with-
that your OMR sheet is not even available.
That is for everyone, my lord, across the board. All OMR sheets that were uploaded, scanned and uploaded that time were mandatorily destroyed for all
I'm
categories.
not on that.
Yes.
But the OMR sheets which they have been able to retrieve
Yes.
from the hard drive,
Yes.
your OMR sheet is not included in that?
They are, my lord.
Then
They
why
are-
are you saying that they are not included?
No, I'm saying that the original OMR sheets which were uploaded.
Forget it. The OMR sheets which have been uploaded include your OMR sheet.
Yes, my lord.
And
That is how I got the.
you had to then file an affidavit. This is not my OMR sheet.
I'm sorry, my lord.
You could have filed an affidavit saying this is not my
I've
OMR
said
sheet.
so on affidavit, my lord.
This is not your OMR sheet?
No, my lord, it's not.
It's
That
not.
is everyone's case, my lord. The OMR.
So none of you, all of you are saying these are not your OMR sheets.
I'm so sorry, my lord.
Now, all of you are saying that these are not your OMR sheets.
My lord, I can speak for myself. No, but
No, you have 300 candidates.
yes, my lord.
They are all saying they're not their OMR sheets.
Yes, the OMR sheets which were found in the hard disk found with Pankaj Bansal are not our OMR sheets.
Okay.
And I've said that on affidavit.
Thank you for supporting
Lord,
that.
may I just, my lord, may I take?
We are untainted. We are untainted, man.
Come little later. Tainted ones.
Only one last submission.
Allegedly tainted. Mr. Raju, you are also allegedly tainted?
My category is untainted as per para 6 of State Service Commission, tainted as per para 7 of CBI. My respectful submission is I respect
Which category? CD, 9th and 10th or 10th or
11th and 12th, my lords. 11th and 12th. So therefore, as per State Service Commission, I don't fall foul. Para 6. As far as The other category is concerned, my lords, OMR, I adopt the submissions of Mr. Sundaram, my lords. That these require further investigation, these need to, and that was the submission of Ms. Padmanabhan also, I adopt both their submissions.
Lord, I'm gonna.
Lords, may I just take 2 minutes, my lord? I have a partner.
You also for tainted?
Match, Lord.
Okay.
My lord, may I take 2 minutes, my lord? My lord, I have a partner going on, my lord. Sorry for this seeking indulgence, my lord. My lord, mine is a case where we were working in the education department from 1999 till 2016 when this advertisement came. The system earlier in West Bengal was that there were 5 zones and you could be only pushed in one zone, you could not go all over. The rules were changed and 2016 allowed that you could be placed anywhere, even near your hometown. So, my lord, we took permission and we were granted to take the examination for the purpose of being taken. We were then again impaneled and our service books were, my lord, continued from before. Our salaries were fixed according to the old service and there is no taint on us, my lord. And we filed an application for intervention before the High Court. The High Court notes that the application is filed, argument is made, but does not go into it further. And we are, my lord, one person is going to retire this year, the coming year, 2025. And we are some 423 odd people, my lord. My petition number is 1.19 listed before your lordships today.
Okay,
So-
even if we dismiss the specially petitions, in your case, we'll simply say, if you are already working, that's for them to decide.
No,
And if, as a temporary worker or casual worker, whatever it is.
no, my lord, in the tainted list, we are not there at all.
We understand.
And we are continuing to work today.
Therefore, what we are saying is, you are not in the tainted list.
Yes.
But because we are annulling, if we uphold the judgment and annul the recruitment process,
Yes.
your services as they existed prior will not be disturbed.
Please, that's all, bro. I am very obliged for that observation. Very grateful.
I stand in the same footing as Mr. Rajesh Kumar. Lord, I appear
Mr. Kumar has, my lord, I am in this,
Complete my submission, Lord.
lordship, I am in similar category. I am completely untainted. I am nowhere, my lord, in 952 or 808 or anywhere. The issue is I am 1.72, my lord,
But were you
47.
working earlier?
Yes, I was employed, somebody
Are you
was,
satisfied with what we have said? Or you want more,
my
something
lord,
more than that?
I support segregation, my lord. I am class
That
11.
we have understood.
That's our class.
But that
Allow me to
our
please that.
statement was subject to the condition in case we annul, accept the annulment of recruitment.
My lord, my lord, secondly, my lord, I just wanted to add 2 more things. My lord, I just wanted, the excess appointment and supernumerary post that was being argued that time, that only relates to, as per my instruction, Group C and Group D. This has nothing to do with class 11, 12 and 9, 10 teachers. And so that issue may not be brought in with the teachers, my lord. That's my respectful
You
submission.
must be a teacher.
I am teacher, my lord, class 11, 12, and page in volume 2 of my SLP, my lord. This is 1.72. I have given complete chart.
We have already said, if you want something more, we can understand. If you're satisfied with what we have said, it may be.
Lord, just
Yes,
I'll
please.
take only 1 minute.
One minute, let Mr. Rohit please lift up.
I'll take only 1 minute, my lord.
Just one last.
Finish whatever you want to say.
Just one last submission on segregation, my lord. My lord, since I am in Group D, the only allegation against Group D is that the OMR mismatch. Now, my lord, there is no allegation of rank jumping, etc. in my case. Therefore, my lord, I say, if at all any segregation should be done in this case, it should be that the people against whom there are allegations of OMR mismatch, they should be allowed to continue for the simple reason that in order to distinguish what is a genuine OMR and what is not, what has been found with Bansal, only a trial where a forensic expert is examined will make that clear. Whereas that is not the case, it's not the complexity of the process required in the other cases of rank jumping, etc. That can be seen much more easily, my lord. Because as per
That's all they said. Okay.
my lord, 311.
Now that's over. alleged
Untainted.
property.
Untainted. I want to just place 5 minutes. 5 minutes. 5 minutes in a written.
I'll take only 1 minute.
No, I am untainted by all.
Okay, mismatch is tainted.
No, but
Okay, yes.
I am untainted by any reckoning. By any reckoning, I am untainted.
Okay,
Just 5
just
minutes.
1 minute. Let him
No.
conclude after that.
Volume 6, page 92 is my written submission. I'll take 5 paras only, and your lordship will see how grossly the injustice is. I am untainted according to CBI, according to everybody, according to the board, according to the government. Now just turn to page 92 of volume 6. I'll read 5 paras only. I'm done. 7-8 minutes.
Yes,
Lordship has got page 92.
yes.
Now, the petitioners were bona fide applicants to a public advertisement for recruitment in 2016, participated in a competitive examination, received the recommendations, and were issued appointment letters. They were appointed validly and remained in undisturbed service between 18 and 19 prior to the expiry of the panel in December 19. We are class 9-10 and class 11-12 out of 4 categories on these assistant teachers which I have given in para 2. Para 3, no adverse action has been taken against me. This is very important. During the course of hearing before the Honorable High Court from 2021 onwards, until the in rem direction was passed in the impugned judgment. It's going on for last 3 years. Further, the petitioners did not feature in any of the list of tainted categories. Justice Kumar asked a direct question. I'm giving an unequivocal answer. No category, no list by any entity. None. That were filed from time to time by CBI and the West Bengal Central School Service Commission before the Honorable Court, underscoring the soundness and legitimacy of the appointment and tenure. Thus, despite there being sufficient material before it to identify and separate the tainted from the untainted, such as the petitioner, the impugned judgment erred heavily by painting all candidates with a broad brush. Prior to the impugned order, I am nowhere in any list. It is also crucial that a vast majority, I am 10,000 persons working from 2018. Now, let us kindly come, and as I said, I'll be very, just come to para 15. I'm skipping most of it. If I will come to para 15 now.
Yes.
The appointing authority and the recommending authority have taken a decision to sustain the entire selection. The expert body involved in the recruitment process found it fit to separate the tainted from the untainted. Why, Wallace? For a very simple reason in my case, which is given in para 16. There are 3 lists made available by the board and the CBI. These are the list of 775 candidates, revoked using Rule 17, both 9-10 and 10-11 classes. List of 942 whose OMRs were found by irregularities, nowhere on the list. I am nothing of this. List of 907 whose OMRs were found with irregularities for 11th and 12th. The first list pertains to the independent exercise carried out by the board of classes so-and-so. And this your lordship knows, Balas. Next, 4th line. Notably, the CBI had filed an investigation. This is very important, lordship, underline this, Balas. Saying that the investigation relating to all 4 categories was complete and charge sheets have been filed. So they found those 4 categories. I'm nowhere there. It's over. Then, even before the High Court, as far as illegalities are concerned, your lordship, I made a table. Your lordship has heard the OMR manipulation issue. Your lordship has heard the OMR issue. Your lordship has heard rank jumping. Next page, page 94. My lord has heard expiry of panel. And my lord has heard beyond the advertised post. I am nowhere, completely, unqualifiedly untainted. Para 19. In fact, the High Court acknowledges in para 329 that the percentages of manipulated illegally appointed persons across the categories other than Group D are on a reducing stage. There were no other information available before the High Court. It's only the High Court which has done it. Nowhere have I been touched earlier in any. Now, just 2 minutes more. Item para 3, big Roman 3. Under that, High Court makes no effort to separate the tainted from the untainted. Comes straight to para 22. Para 22. The High Court, this is a blanket approach, throwing the baby out with the bathwater. Completely blanket. The High Court proceeded with option C. C is the cancellation of the entire selection process. Your lordship, I would say, are obliged to do B if your lordship finds the untainted category, which the High Court did not do, is my humble submission. The only reason to cancel the entire selection according to the High Court is because it is difficult to separate the chaff from the wheat. That's the main reason given. However, no effort is made by the High Court to separate the tainted from the untainted, despite abundance of material available.
In Kalon's case, this court laid down a standard of absolute impossibility. I've given that at page 40, para 43 of that judgment. Was only in case of absolute impossibility. Convenience is not a defense. Careers of 10,000 in my class will be spoiled, and the answer can't be it's inconvenient to separate or segregate.
Yes.
Then, 24, the aforesaid list provided by CBI and the board have not been adverted to. If the High Court is passing a blanket order unseating me, then it had to at least say that list 1, list 2, list 3, list 4. Where are you, Mr. Singhvi? No exercise, para 25. In para 325 and 336, that is a whole bunch of paragraphs, High Court holds that the original OMR sheets are not available with the board, and therefore an exercise of sifting the grains is not possible. Is it somebody's fault if the original is not available? You have enough material from the CBI. How has the CBI made the list then, How has the board made the list? They could put up their hands and say, all 10,000 of you get out because we don't have the original. That can't affect my career, I'm completely outside the system and completely blameless, Then, in para 29, I've dealt with Kalon's case, which I've already made. I'm not reading it, Along with Kalon's case, I've given 3 more judgments, If you're, as a matter of fact, it's a grave miscarriage of justice. Your Lordship has material to not punish the innocent. You will not blanket, club me with the guilty and throw me out. That's these 3 judgments, Kalon is the 3-pronged test. It's very important, Your Lordship juristic principle is the 3-pronged test of Kalon. 1, 2, 3 I have given. I'm not reading it to save time. The 3-pronged test is very clear. The High Court doesn't apply any of this 3-pronged test, And then lastly, is para 33 onwards, where it clubs group C, D, and everybody else. I would in conclusion say this. Your Lordship is going to be allowing a very grave injustice to be perpetuated if this kind of clubbing and blanket approach is allowed. You're here, fortunately, you have an individuated approach. Yes, yes. Lastly, one thing, only one minute more, only less than a minute. Para 30, I forgot to read, just note 30. That's the 4 lines of 30 are very important. There are no findings in this regard as far as the majority of appointees being involved in the so-called illegality.
No, that's irrelevant.
No, next sentence. As far as teaching staff is 8% and 14% are found.
No, 1 minute. That's not the point. What the argument you're raising is, until this malafites are attached to me, that's the argument you're raising.
That's the basic argument. I'm not at all involved in anything.
That's a separate argument. Even if we are not able to, that's an argument, even if we are not able to bifurcate the tainted and untainted, then even apply the principle that if I'm not involved, then protect me. That will be difficult to accept.
Mulad, I just, one second.
List of tainted candidates, my lord. List of
I'm
all.
appearing in 1.1, Mulad.
Even if we accept that argument, then in all cases where there's gross irregularity or not gross illegality in appointment, and we are not able to segregate the tainted from the untainted, you will have created.
No, Malas, the first objection is that there is a material to segregate. The three lists are there. Those three lists are there. What else do you need to segregate? Malas, in 4 years, would the CBI put me in some list? Would the board put me in some list? Would the SSC put me in some list? Whereas I can't prove a negative, Malas. They've been doing lists for the last 4 years.
Malaj, just I'm appearing in 1.11. I'm in the same category as Dr. Singhvi's client. Malaj, I just one small submission break. It'll take 30 seconds. Malaj. And that is that the CBI has got, Malaj, the material from the hard drive. Having got the material, they have segregated themselves because they have, Malaj, said that 92% in 9 to 11 are not tainted, but 8.24% are. And as far as 11 and 12 is concerned, 14.57 are, 86 are not tainted. So the CBI has done that exercise. And having done that exercise, then, Mullahs, we can't be punished. And I'm in the same category. And the Rich Court, what it does is it takes C and D category, the other category where it is 30% and 40% tainted, and clubs it together. Instead of, Mullahs, the 19,000 people, 8%, or 14%, Mullahs, take an average of 12% are tainted. You will, Mullahs, throw out the other 88%, Mullahs, because 12% are tainted.
Please, on that case of difficulty, we have understood your argument because CBI itself has bifurcated.
Bifurcated, correct.
Yes, they have done. That's all.
I am in the same category, my lord. I am in the same category as that of Mr. Singhvi and Mr. Sibal, my lord. Only difference is Group C and D I represent, my lord. My SLPs are right on 1.5 and 1.13, my lord. My submissions are at page 100, volume 6A. But my submission is that, like your lordships have noticed, from para 288 till 309 of the impugned judgment, the High Court has taken note of the segregation information that has been given, my lord. In none of the reports that our names have figured. We have been appointed in the first list in April 2018. From then, there is no material, nothing. Till the impugned judgment, we have not been called upon to do anything. Our name is not mentioned anywhere else. Now, the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272, para 363, the direction number 4 will say that persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR but obtained appointments, must return all remunerations and benefits received by them in the state exchequer along with interest, etc. My lord, if this kind of information can be taken and their appointment can be set aside with the same kind of information, my lord, how can the item 2 order can be passed, my lord? All appointments granted in the selection process involved is violative of 14 and 16, so all are declared null and void. So this direction, number 2, my lord, cannot stand because there is enough material with the CBI and also, my lord, in all the affidavits which are placed before the High Court, which your lordships have seen. And secondly, my lord, like Mr. Singhvi was pointing out, my lord, Inderpreet Singh column really says, my lord, there are 3 tests which I have extracted in para 2.3 of my submissions, which exercise has not been undertaken by the Honorable High Court, which says, my lord, just I'll read this. If the services of the appointees who had put in a few years of service were terminated, compliance with the 3 principles at the hands of the state are imperative. That is, to establish satisfaction in regard to the sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was tainted as far as them. To determine the question that the illegalities committed go to the root of the matter which vitiate the entire selection process, such a satisfaction as also sufficiency of the materials were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether the sufficient material present enabled the state to arrive at a satisfaction that the officers in majority have been found to be part of the fraudulent purpose or the system itself was corrupt. None of these, my lord, have been carried out. And para 93 says, it is one thing to say that having regard to the nature of the selection process, no person is appointed from the select list as no person has a right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for terminating the services of the officers who had completed about 3 years of service in that case. Some of them, as noticed herein before, passed departmental tests. Some have been given higher responsibilities. They had completed period of probation and some were nearing the completion thereof. They presumably had been working to the satisfaction of the authorities concerned. Same here, my lord, from 2018 we have been continuing in group C and D. No action against us, my lord. Till date, no names have come out, my lord. We have all altered our position in the society. We have improved our lives, my lord. Our lifestyles have changed. And we have, some of them have entered into family and, my lord, created loans, etc. Their rights will have to be protected since they have not been, my lord, a part of any of this. Even, my lord, in para 2.5, my lord, at page 100 of volume 6A, the judgment in Rajesh Putanvalli Kava will say that, my lord, is of significance. It's humbly submitted. It's not a case where massive fraud is said to have permeated the entire process since its inception or in the conduct of the examination itself. Furthermore, the untainted candidates, including the petitioners, stand to lose their job after having worked for 6 years without, compliance of Article 311.
Okay.
My lords, I appear for the,
There was a bad committee.
my lords, I appear for the,
There is
ESP is standing on his legs over
I only praise. Just one thing, para 3.3.
My arguments have been raised, not only
Lord,
small.
This will give.
There,
create-
You have understood your argument.
my lords, I appear for the,
Since the material is already.
my lords, I appear,
At best, my lord, there can be a committee which can be appointed if your lordship so desire, my lord. I have just suggested.
Can I say
para
something?
5.1.
I'll not repeat it.
A committee of the retired judge of this honorable court with a technical expert from NIC.
Okay.
Some
fine.
retired member from. the
Okay,
Lord, I'll take only 1 minute.
But our appointments have to be protected is my
The
prayer.
untainted category which Dr. Singhvi addressed your object of, there are 1,800 people approximately out of 12,000 who have actually given up government jobs and come here. And so our written submissions are at page 49 to 54 of compilation C. So, my lord, please see the inequity for us. Untainted, not in any list, not named by anyone, and given up government jobs to come to better our career prospects. And now we are faced with this difficulty.
my lords, I appear for the, if your lordships will permit me.
Just 1 minute.
Yes.
Can I, my lord,
Judge Mr. Deveri.
My lord, in a similar manner.
Judge Mr. Deveri wants to argue, then we.
Most of my arguments have been covered, so I won't repeat. My only point was that kindly have just para 3 and 5 and 2 paragraphs of that report, and I'll show note this concept of mismatch, which now is the center point of debate here, note, is wholly not the baseless. Lordship may kindly have para 3 and 5.
3.305.
3 and 5.
Yes. That's the
Like
CM.
starts from paragraph 5.
Yes.